Today's training topic is practical information on supported decision making. And my colleague and wonderful advocate, Kelsey Lesco, who works at Disability Law Colorado, is our presenter today. She is the Colorado Legal Assistance Developer for Elders under the Older Americans Act. In this position, Kelsey oversees a network of attorneys who provide free legal services to older adults, members of the public, and other professionals. Kelsey also works to address systemic issues impacting older adults in Colorado through legislation and public policy development. In addition to a law degree, Kelsey holds a master's in public administration. Let's please have a warm welcome for Kelsey Lesco.
All right, good morning. So it's 9 o'clock on a Wednesday, so please feel free to ask questions. 2 hours of a presentation in the middle of the week in the morning is difficult for everyone. So I hope you will. So I'm going to talk about supportive decision making today, which is really just a common sense method for supporting someone who has some sort of diminished capacity in making a decision. So I'm just curious, has anyone here used a formal supportive decision making process before? No, so I don't see anyone. So that's great, because this is going to be an introductory training. And to do that, what we're going to talk about is just what supported decision making is. We're going to talk about how it's an alternative to guardianship, and then what guardianship means and what the history of that is. Then the importance of choice to just living as a person, to the dignity of choice, because that is a key component of supported decision making and why we all need to put a little bit more effort in to be able to encourage this process. And then we're going to talk about challenges and limitations, because there are a lot with supported decision making. And one thing you're not going to hear me say today is that this should be used in every situation for every person, because it shouldn't, because there are some issues with it that we need to be realistic about. So just to let you know a little bit about me, I work at Disability Law Colorado. So Disability Law is a pretty diverse organization. We have sort of two wings to it. One is an older adults program, where we have my program, and then also the State Long-Term Care Ombudsman and the State PACE Ombudsman. And then we have the protection and advocacy system for people with disabilities. And they work to enforce civil and human rights of people with disabilities. So we have a lot of crossover work. But also the important thread that runs through all of our programs is that our mission is to protect and promote the rights of people with disabilities and older people. So if I have a bias, and I think it's important to acknowledge bias in supported decision making, it is to make this work, because that's my job. My job is to promote individual rights. All right. So supported decision making is where we help someone with limited or declining capacity to make decisions. So this process in and of itself is about empowerment. It's about empowering a person to make choices with the assistance of friends, family members, and other supporters who are people dedicated to assisting this person in understanding their options. Now, in this process, the supporters will act as advisors to the person, where they'll explain what the options are, explain the risks and benefits, provide guidance, and then if it's necessary, they'll help the decision maker in actually taking the action to make the choice. Now, one growing role in this is that of a facilitator. The United States is a little bit further behind some other countries in doing this, but in Australia, which is essentially the gold standard for supported decision making, facilitators are becoming more and more popular. And this is exactly what it sounds like. It's just a person that's going to help the parties work together. They're going to help the supporters properly support without imposing their own views. They're going to help the decision maker understand the process. But in all of that, they don't have any decision-making input. They shouldn't be saying anything about this. They're just there to make the process go smoother. So clearly this is not brilliant. This is not new. Within the IDD community, the intellectual and developmental disability community, this has been used for years as a way to make decisions, really informally. And really, it's how most of us are going to make complicated decisions every day. Like, for example, a few years ago, I had a really severe knee injury. So when this happened, I'm not an orthopedist. So what I did is I talked to the orthopedist. Then I talked to another orthopedist. Then I talked to my family, and I talked to some other people who've had similar injuries just to find out, what option should I have? Should I have a knee replacement? Should I have them try to surgically repair it? And through all of that, I was able to come to the decision based on what I wanted for my future health by getting advice. And this process really isn't any different than that. So I think the question becomes, why do we need a formal supported decision-making process? And there are some reasons where if we have formal supported decision-making in statute, then we're going to go to it more often because that's going to be a tool we have to look at. As humans, we tend to take the option that's most easily available to us. Right now, that option is guardianship or power of attorneys and surrogate decision makers. But I think a larger issue really goes to bias. When I or you or someone else who has unquestioned capacity goes and they ask questions, they try to get advice, and they try to make a well-informed decision, we're really congratulated for being wise and making the best decisions we can possibly make. But when someone who has dementia or someone who has an intellectual or developmental disability, when they go through that same process, then as a legal culture, we jump to the conclusion that, well, they can't make their decisions, and maybe they can't make any of their decisions. So we're going to need to try to put a surrogate decision maker in place. So that may not be true. Some people may need help in some areas and not help in others. And some people may need help to make certain decisions, but not help to make other decisions. So we've really kind of simplified the process of what choice really is for people who have diminished capacity. Now, I also believe that the desire to make choices is part of a basic human drive. We all want to be independent. Just think about it. How many people in here want to be told what to do all day, every day? How many people want to be told when to get up, when to go to bed, when to eat, when to take a shower, when to exercise, when to go outside, when to have your recreation? Well, we don't, because that's a prison. Part of the punitive process of being in prison is that your choices are taken away from you. To take another example, how many people in here would really like to work for a micromanager? We don't. And numerous studies have found that what a micromanagement environment does is it causes high turnover, low morale, decreased productivity, and what I did find as, and this is a quote from a peer-reviewed scientific article, general snarkiness in the workplace. So we simply don't thrive in an environment when all of our choices are controlled. Now, as I said before, I believe in empowerment, but I'm also realistic. So we need to be able to think about how supported decision-making can help to empower choices, and when it would actually exist to take away choice. Because supported decision-making is essentially a group of people sitting around a table making a decision. Now, if the decision maker really doesn't have capacity, then what that becomes is one person or two people or a group of people sitting around a table making decisions for someone without any due process or court oversight. And that's a recipe for abuse right there. So, first let's talk about guardianship, because guardianship is what we're going to right now to help people make choices by taking their choices away. Now, guardianship is where a person is empowered by the court to make some or all of the decisions for another person. Now, the history of guardianship goes back to Greek and Roman times, and this evolved as a method to control property. It wasn't about the person. Just to give you an example of a pretty standard guardianship case in the foundational law for this. The Greek philosopher Sophocles, he wrote Oedipus. When he was writing that play, his sons became so concerned that he was so preoccupied with the play that he didn't think he could manage his estate. So they sued for guardianship over him. All right? Clearly he had capacity. It wasn't about him. It was about preserving the property. Now, as we go on through history, in the Middle Ages, this continued, and what were called tutorships. It fell to feudal lords. Then in the 14th century, there a law passed that said that there is a royal prerogative for the king or state to hold any necessary guardianships over their subjects. This became known as parens patriae, which some of you have already probably heard of. That means to make decisions in the place of a parent for someone who is unable to do so themselves. And this is directly where our modern guardianship law is derived from. So why am I going through history at a legal training in the morning? Because that's not fun for anyone. The reason is because we need to understand the history of guardianship to understand that this is truly a paternalistic process. All right? That is inherent to guardianship. It's all that it can be. And paternalism is a trigger word for a lot of people. It's not always bad. Sometimes we do need to make decisions for other people because they are unable or to make those decisions, or they really just don't want to make their decisions. And I've seen that in sort of advanced cases of dementia. It's rare, but it can happen, and that's something that we need to acknowledge. Some people aren't able to make their decisions or aren't able to communicate that. But what guardianship does do by creating that paternalistic and protective relationship is that that's going to create a constant tension between, protection and autonomy and your rights and your wants as opposed to what the person needs. So for those reasons, guardianship really is an extreme measure. In fact, from a legal perspective, that is the most extreme civil remedy we can take against another person. So this is a dangerous weapon. It can also be a very important tool, but it can be a dangerous weapon. And as a nation, we are starting to move away from that. Now, in Colorado, we have a bunch of different types of guardianship. There's sort of a temporary substitute guardian and emergency guardian, which are appointed for briefer periods of time and sort of outside the process. And then what we have is a limited guardianship and an unlimited guardianship. So a limited guardianship is someone who is appointed to make specific decisions for the person for whom a guardianship is sought. So this would be a decision, for example, as I will be appointed as the guardian for housing. Then we have the unlimited guardianship, and this is exactly what it sounds like. This is a person who is essentially appointed to make all of the decisions for another person. And you can see what the statutory language for that. They can apply and receive funds, they can establish residence, they can consent to medical treatment. With court authorization, they can even consent to marriage and divorce and adoption. So these are very, very broad powers. Now, the problem with this is that, and we don't have good statistics on guardianship nationally or in Colorado, but it is estimated that nationally the unlimited guardianship is used at least 90% of the time. So that's a lot. 90% of the time we're going to essentially take away everyone's decision-making capabilities. And there can be good and bad reasons for this. Some reasons are people aren't sure what to ask for. But we have this huge tool in the statute that says you can have an unlimited guardian, so you can just make all the decisions. You won't need to worry about anything else. So we go to that. Can also be situations where in Colorado and in most states, if there is going to be any sort of litigation about the guardianship or going back to court to ask for more things, that's going to come out of the ward's estate. So there's some pretty huge financial ramifications for someone if they have to keep going back to court for their guardianship. But the point remains that we, in all likelihood, overuse these unlimited guardianships. So one of the benefits of supported decision making is that having this in statute, again, would help us address some of these systemic failings. So we have guardianship who can make decisions for someone to assist them in getting into an assisted living or a nursing home. Well, we have that tool in statute, so we'll go get a guardianship, and then that solves that problem right now. If we had supported decision-making in statute, which we don't in Colorado, then there would be another process that a third party could rely on to say, oh, okay, but they went through the supported decision-making, they made this decision, and supported decision-making should bring them to the level of informed consent for a decision, so we could follow this too. So one thing that we should be aware of is what guardianship is like in Colorado. Now, Well, it is very broad. There are some limitations, and they're pretty extensive if you really look at them. So guardian may only exercise the authority as necessitated by the ward's limitations. They should encourage the ward to participate in decisions, act on the ward's own behalf, and develop and regain capacity. And they should consider the expressed wishes of the ward. So together, what that all means is that a guardian should be learning what the person's choices are. They should be helping them in making choices. They should be helping them and develop the capacity to make choices. So that's the statutory obligation. When I get questions about can a guardian do this or should they be doing this, well, it's generally this analysis that I'll go through with the person, like are they meeting these requirements? So these exist. The problem with these is how do you enforce them? The court doesn't have any sort of law enforcement agency that's working to specifically monitor guardians. Instead, guardians have a reporting requirement where they should submit a report once a year. We don't really track and see what a guardian does. So while we have these protections, whether or not they're actually being used, we don't know. Now, just to give you an idea of where we are coming and have come in our thinking, you know, on the, I guess it's on the left up there, that's the first guardianship law. That's from Roman. That's the first written guardianship law that we have. And then on the right is the UN Convention on the Rights of People with Disabilities that says that people with disabilities enjoy legal capacity on an equal basis to all others in all aspects of life. Now, the US quite famously is not a signatory on this. So we didn't agree to this. But this is where we've come in our thinking. And supported decision-making and the growing impetus on getting this into statute and using this more in our day-to-day interactions with people with diminished capacity is really reflective of the shift in thinking that we've had really in the last 10 years is when it's really started to take off. Now, I think we need to talk a little bit about why choice is so important. Now, I'm not a psychologist. I'm not a psychiatrist. I don't have any of this sort of training. And I'm sure many people in this room have more than I do. But I'm just going to try to talk about this a little bit. And if I'm wrong, please correct me. If I'm really wrong, please correct me privately after the presentation. But learned helplessness theory. So this is a phenomenon that's been observed in both human and other animals, where when you're conditioned to expect discomfort and believe that you have no control, eventually you stop trying to avoid it. This came about based on some classical conditioning experiments that happened, I think, in 1968. And the ethics of psychological experimentation has come a long way since then. And I don't mean for this to be disturbing, but this is the experiment. So these psychologists were doing some classical conditioning with dogs and electric shocks. So what they'd do is that they'd have a dog and they'd shock it. And it had no way to control or prevent that shock. And then they had another group of dogs that they didn't shock. Then in the next stage of this experiment, what they did is they put the dogs in this box with a barrier in between. And on one side of it, the ground was electric. You could run an electric current through it. On the other side, you didn't have that. Now, what they found is that the dogs that had not been exposed to a shock they could not control, when that shock went off, they just jump over the barrier. But for those dogs that had been exposed to this shock that they could not stop, they could not control, they didn't even try to escape for the most part. In fact, oftentimes they just lie down and start whimpering. And then the researchers went on to conduct some other experiments that confirmed this. So that's not good. I mean, that just shows that we can be it's learned because it's a learned behavior. It's learned that if we believe that we don't have a choice, eventually we stop trying because we can't overcome it. And in the 1970s, this was also confirmed with humans, where they had 3 groups of people. The first group was put in a room, a loud sound would go off, and then if they hit a button, the sound would stop. For a second group, the sound would go off. They'd hit the button, but the button was deactivated. And a third group didn't They just sat in a room and were wondering why they were there. So they then took these people and put them in another room where a loud sound would go off, but if they manipulated this lever, that sound would turn off. For the group of people who were in the room with the deactivated button, who couldn't control the sound, they didn't even try to manipulate the lever. All the other groups did. They were able to manipulate the lever and turn off the sound. So when humans or other animals come to understand or believe that they don't have any control over what happens to them, they begin to think, feel, and act as if they're helpless. And studies have shown that having little control over choices has been associated with negative health outcomes. While having increased control has been associated with increased well-being, where people are generally healthier, more independent, less isolated, and more resistant to abuse and exploitation. And more resistant to abuse and exploitation because they're used to because they believe they can have some control to impact what's happening around them. You know, there was even this one study a few years ago in nursing homes where they found that if they just did something simple, like allow the residents to decide where the chairs will be placed in common rooms, or allow the residents access to the remote control for the TV. Just those simple acts increase health outcomes for those residents. So, supported decision-making principle, first, dignity and importance of choice. This is important for our psychological and physical health. Second, that choice is a fundamental human and constitutional right. Again, this speaks to the importance of choice, to human dignity. You know, on the fundamental human right level, we have the UN Convention for the Rights of People with Disabilities. On the constitutional level, in the Supreme Court, a case in the 1960s called Griswold v. Connecticut, a very famous case. This was the contraception case. And in that case, a woman decided that she wanted to get some contraception, and the pharmacist wouldn't sell it to her. So this became a Supreme Court case, and essentially what the Supreme Court said is that we have a lot of rights in the Constitution. I can't name them all. I'm not sure what they all are, but we must have the right to make choice. And you have the right to make choice so you can buy your contraception. Another principle is, and this is a very important, capacity is complex. We tend, and you can see by how often unlimited guardianships are used, we tend to view capacity as a black or white issue, and it's not that. Some people can understand certain aspects of their life, but not understand other aspects of their life. I once had a client who, this is when I was working in disability, who due to brain injury could not read numbers, could not understand them, could not manage any of his money. But he could still decide what he wanted from the grocery store, and he could still get a sense of how much things cost. So he understood how much things were worth to him. But, you know, capacity is just such a complex, and as our understanding of neuroscience grows, we'll understand this more. But we need to treat this as an individualized way of living. We can't just simply say, well, you don't have capacity, so you need a guardianship, and you can't make your own decisions. The next one is person-centeredness, and this is a quick video that sort of explains it better than I could in this short time. Take it a second.
To understand the need for a person-centered approach to providing long-term services and supports, we must understand person-centered systems and the federal context that is assisting in developing those systems. Here, we can see a timeline framing some of the events that took place that have contributed towards a more person-centered approach to service delivery and individual choice. One of the more well-known movements that happened early on is the Olmsted Act. Two women living with intellectual disabilities and mental illness wanted to transition from a nursing home to the community. The care team surrounding and supporting both women were in complete agreement. Each woman could have her needs adequately met in the community. However, due to a limited number of slots within Georgia's Medicaid program for home and community-based services, each woman remained institutionalized long after their request for community placement. Both women sued the state of Georgia, alleging that failing to discharge them to a community-based setting was discrimination under the Americans with Disabilities Act. The case eventually made its way to the Supreme Court. In 1999, it was decided that the women had indeed been discriminated against. After the Olmstead Act, we can clearly see the progression of person-centered programs at both the state and federal levels. One of the very first actions taken by President George W. Bush was to sign the New Freedom Initiative, which clearly states that its main function is to help ensure that all Americans have the opportunity to live close to their families and friends, to live more independently, to engage in productive employment, and to participate in community life. So what do we mean when we talk about a person-centered system? At the core, person-centered systems are about the individual, their goals, and their desired outcomes. At the very base of person-centered systems, you will find a deliberate culture. This is a shared, deliberate set of assumptions shared by a group of people. In the context of this discussion, a deliberate culture would be exemplified by professionals in an organization understanding that all people in need of long-term services and supports have the right to access information concerning their options in care and supports. The second tier of person-centered systems would be espoused values. These are verbal expressions that come from the adoption of a deliberate culture. Using a person's name instead of resident is an example of an espoused value. When assisting people with long-term support needs, asking them about their preferences, strengths, capacities, needs, and desired outcomes is a perfect example of an espoused value. The third uppermost tier concerning person-centered systems is represented by artifacts. Artifacts are actions that demonstrate the deliberate culture and the espoused values of an organization. Concerning the support of persons in need of long-term services and supports, the delivery of services in a manner that respects the individual's preferences is an artifact in that the service providers are demonstrating their willingness to partner with the individual to meet their unique needs and reach their own stated goals. Providers are espousing their values and shared assumptions in asking the individual about his or her preferences, and then are demonstrating an artifact by making every effort to respond to those needs. When we are able to utilize these three tiers in creating a person-centered system, we are able to shift from a methodology of service delivery that focuses on a menu of services to a focus on informal supports, individualized choices and goals, and a process of planning that promotes trust, cooperation, and creativity. This creativity, trust, and focus on individual goals are all key factors in supporting and assisting individuals in need of long-term services and supports to achieve his or her personal goals. One of the challenging aspects to this shift in culture comes when many professionals feel that a person-centered approach means that the individual gets all of their needs met, and they fear they are setting the person up for disappointment or failure. A person-centered approach helps us to better understand the individual's strengths, needs, goals, and values to help design a support plan that responds to the individual's desires. There are a number of problem-solving methods that we can learn by following a person-centered approach. Let's talk about Ruth, a woman living in a nursing home. Ruth is no longer capable of living at home, though she greatly desires to return to her community. Instead of asking Ruth if she would like to learn about her options for potentially returning to the community, we could ask Ruth instead what makes home a true home. We can ask Ruth about the garden she used to have, and we can talk with Ruth about how she loved to bake, and about how she loved the smell of laundry that had been dried outside in the sunshine. By having this conversation before jumping to talking about living arrangements for Ruth, we're not only learning what would make Ruth happier, we're connecting with her, building trust, and are able to learn more about who Ruth is as a person. Now we can take steps to create a living environment that respects Ruth's values and reflects what home really means to her. Ultimately, this process is an excellent example of New Hampshire's movement towards a more person-centered system. By asking an individual directly for their preferences, and then by acknowledging those preferences and initiating the service planning process, we're able to support the individual's personal goals. One of the most important responsibilities that we have as service professionals is to provide the individuals we serve with as much choice and control as possible. By adopting a person-centered culture and by demonstrating this culture, we are celebrating the unique attributes of the individuals that we support.
Okay, so that's just a short video to sort of explain person-centeredness kind of in a nutshell. So person-centeredness in supported decision-making is that you want to value the person's preferences. You want to be asking them. You want to make what you're doing, make the process about the person themselves. Now, in addition to being person-centered, supported decision-making also should be person-driven. Person-driven in some ways goes beyond person-centered principles. It goes to the decision maker themselves. The person with capacity issues should be the one to decide that this meeting is going to take place and what they're going to talk about. And it really should be about this person being able to communicate what they want. And the supporters should be there to be able to fulfill the desires of the decision maker. So now let's get into some of the more practical stuff now that we have basis on what supported decision-making is. So supported decision-making, you help someone with diminished capacity to make a decision by breaking down the information to make it manageable. And you do this in a way that respects the dignity of choice, that respects the dignity of the person, and that seeks their input in all stages. Now, how do you get to that point? Well, one way is called the practical tool for lawyers. It's from the American Bar Association. And this is a tool that's designed specifically for attorneys when they're presented with a client for whom a surrogate decision maker may be an issue. And this is just a process that lawyers specifically, but really I think can apply to anyone because a lot of professionals get into these situations. A process that you can go through to see if, will this be an appropriate way for supported decision making? And I'm not going to read all of this. I think it would just be a little easier if we go through an example of it. So when I was in law school was the first time that I did supported decision making. And there's this one gentleman who we facilitated his supported decision making group. So just read this to you. So this man, John, he was 66 years old, and he did have some intellectual and developmental disabilities. In the past, guardianship had been suggested for him, but both John and his family resisted this. John wanted to live alone, and he enjoys having his own room and apartment. And with the support of his family, John has been able to live independently since he was 25. He also has a job at the local grocery store that he really enjoyed his job. And when he puts his schedule on the fridge every Sunday when it's printed, and by doing that, he's never been late for a shift. John does not drive, but when he is taken to the store, he's able to do most of the shopping for himself. And for medical decisions, John is very anxious around doctors and has a fear of needles. In terms of his private life, John has a very close family. He was extremely close with his mother, who he saw daily, and his mother would assist John by driving him to appointments because John does not drive, assisting him in cleaning his apartment and preparing meals. And while John has his own bank account, his mother would pay his bills for him and manage his money. In addition, his bank has some hesitation about serving him because they're concerned about his capacity issues. John also has a brother in town and he actually was an executive for AT&T. And while his brother was largely supportive, he did travel often for work. His brother's also been increasingly concerned that as John gets older, that he may not be able to live safely. And in addition to this, John also has a cousin who's in town who he calls regularly. Ann, if you would just distribute the handouts now. I have this written out for another thing. It may just be easier. So a few years ago for John, his situation began to change. So physically, John's been having some issues associated with aging, and he walks with a cane now. So he's having some mobility problems. He's also going to need to get a hip replacement in the next year or two. 3 years ago, John also had a stroke. And since he's had his stroke, he's found it more difficult to make decisions, and he's having more trouble with memory and identifying consequences. Now, in addition to this, about 6 months ago, his mother died. And this was a huge blow to his support system. So this was the first case I had in supported decision making. And to go through this tool with this, first we assume that we're not going to pursue a guardianship. The next step is we need to think about the reasons for concern. And we're going to clearly identify those reasons. Like for John, his support system, how strong is his support system with his mother passing on and his brother being out of town a lot. Some other issues on the personal level. What about his memory issues and his cognitive problems? He also has no one to manage his money. So this is going to be a problem. And he's having problems understanding the consequences and what's important to making decisions. So these are some pretty significant concerns to have. Our next step is to ask, are these going to be permanent concerns or are they temporary? So as far as temporary goes, he had a stroke. People can improve functionality after a stroke for years afterwards. In this case, and with John, I know that he had permanent issues with capacity related to this stroke, but potentially it could improve. All right, so we have some concerns. We have some hope that things will get a little bit better. Then our next step is to see if there are any community resources that can address any of our concerns. So in John's situation, who could he reach out to? Well, he has an intellectual and developmental disability, so the advocacy organizations, the community-centered boards, and so forth. He is also an older adult. You know, would there be any community centers? Are there any support groups? Then also, what about money management programs if he doesn't handle his own money? Could he just look at a rep payee program? So you're going to want to think about all the different community resources out there that could assist a person in making these decisions. The next thing we're going to ask is whether the person has already developed a team to help them make decisions. In John's case, possibly. His brother is still there and they've been close. And in this case, I can tell you that his brother was able to be on his team, but his brother's interests were a little bit different than his. His brother was more concerned about protection, and John was more concerned about being able to go to work and live in his own apartment. He also has his cousin. You know, maybe those two could be supporters. And then in addition to those, you're going to want to, again, think about the community and reach out to people who could be brought in to be supporters. So for him, you know, community groups. What about friends? Maybe he has some friends that could help. And work. We know he has a long-term job. He hasn't been late in 5 years. So we can always go to his work and see if there are any people there who really want to support him. Then we'll go and think about what John's strengths are. So for him, a strength is he gets to work on time. He can follow written directions. And this guy could do this really well. I mean, if it was written down, he could do it. He also has a desire. He wants to be independent. He lives in his own apartment. And he's resisted guardianship, so he has a desire to do this. And he does have a support system that's stronger than a lot of other support systems out there for many other people in similar circumstances. Now, with regard to limitations, you're going to want to look at that at the same time you identify strength, and you're going to have memory problems and potential envisioning potential outcomes as limitations. And then in the next step, you're going to screen for challenges. So challenges are not challenges towards John. These are challenges to the supporters and the support systems. So these challenges would include, are there community resources that could come help him? You know, if John lived in an extremely rural part of the state, would there be a homemaker service that could come visit him? Would there be someone who could come over and cook for him because he needs some assistance with that? You're also going to want to think about what his supporters' limitations are and what challenges they could face. He has a brother who travels for work and who has told him that he's got concerns about him living alone. So he may have different interests and he may not be there. Then you have a cousin. We don't know too much about the cousin. I can tell you that she lived 2 hours away. She had a child with an intellectual and developmental disability as well, and she called him daily. So she turned out to be his main supporter. And then another issue that we should consider is even if the services exist out there, right, his mother passed away 6 months ago. Is he safe right now? It's going to take time to set up services. So you need to understand that this would be an extended process. And you want to see how much time it's going to take to get those services set up and what you could do in the interim to make sure that he can stay supported and stay safe and live successfully in his home. Because the sort of ugly reality out there is that for a lot of people, if they have a disability, if they have a cognitive impairment, and if they mess up once, if they get themselves into troubles once, they get institutionalized, nursing home or assisted living, it can be very difficult for them to get back out. So we want to keep people safe, but at the same time, we have to respect the dignity of choice. And we have to be able to take some sort of protective measures to make sure that people can be successful. Because if they're not successful, then that could result in institutionalization too early, if it's going to be necessary at all. And then in the next ones, you appoint a legal supporter if necessary. And then if you did go through all this and you found that a guardianship was still necessary, let's say, for example, that John's brother declined to be a supporter, John had another stroke, his cousin wasn't available, and APS is beginning to get involved because even his work is having concerns about his safety because he's not there on time, he doesn't appear to be eating. Then if you had any sort of petition for guardianship, then you'd want to really limit that to as few choices, as few powers as possible for the guardian. So once you get through the practical process, and you say, okay, this person is appropriate for supported decision making, then you need to go to the supported decision making process itself. And that's where you're actually sitting down with the person and trying to help them make decisions. Now look, there's no really specific way to do this. Everybody approaches decisions differently. Everybody likes to make their own decisions differently. And this is person-centered, so you need to respect that. But generally, our decisions occur in 5 stages. Where first we're going to identify options and gather information. Then we're going to weigh choices, make the choice, act, and reflect. Now in this general decision-making process that we all have, for supported decision-making, the reflection on a decision, the being able to go back and say, okay, I made this decision, was this a good decision? Or should I have done something differently? That's absolutely critical. For people with disabilities in particular, in these cases, they've had a lifetime of people making choices for them in some cases. And like with anything else we do, the more often we do something, the more often we practice it, the better we get at it. Decision-making is no different than this. So part of the goal of supported decision-making is to support a person in learning how to make better decisions and learning how to do what they want. The same rationale, I believe, and we'll go into some limitations of this in a little bit, would apply to older adults. Because even if you have a lifetime of decision-making skills behind you, when you do get into the stages with dementia or with other cognitive declines associated with aging, first, sometimes your priorities change. Now, one of the funniest conversations I ever had with my grandmother was when she was in the later stages of dementia. And she just came into my room one day because I was visiting my parents who she lived with. She sat down on my bed and she said, you know what, I've been cleaning up after your grandfather for 60 years. When do I get to retire? He retired 20 years ago and he's not doing anything. I'm not going to cook or clean anymore. She did not cook and clean ever after that. So priorities change. What you want to do changes. But also your ways of thinking change. Now, in person-centered care for dementia patients, one thing that we acknowledge is that even with dementia, the self still exists. Even though some components of the person that we once knew have declined, that's still that person there. And we can still recognize that this is someone we know, someone with opinions and preferences, and we just have to find a way to get to them. And we also do, and obviously there are limitations with advanced dementia, but we have to find a way to try to understand what their choices are. And to a certain extent, they have to understand what they want and what options are available to them in a new way. So it's still a learning process for them. Now, within how supported decision-making will operate in and of itself, there are certain things that we all have to do. How I was raised, we called this manners. But for a lot of people, we kind of need to point it out. So first, you always provide information to the person. Don't just assume they can't understand it. Provide information. If they don't understand it, provide it in a different way. If they still don't understand it, then try to break it down even further. But in any event, they need to understand the information. Then you have to communicate in a way that the person understands. I can get up here and quote statutes for the next hour. I'm not doing that because it's incomprehensible to anyone other than, me and the person I work with. It doesn't make any sense. So it doesn't make any sense to try to make decisions on these high-end complex language that we would for other ways. Like, for example, well, we can contact the SEP and talk about your HCBS benefits, but I don't know if you're going to have the home care that you need for this service. So we might want to consider about long-term care options. They won't know what that means. What you can say is that, we can talk to an agency that may be able to help you get some services in your home. So just communicate in a way people that understand. Then always offer choices. It does not matter if you don't think they will understand them. The choices need to be offered because that is the only way that a person is going to be empowered to make a decision. No, we don't all just operate in this world of sort of universal and almost eternal knowledge. Whenever we're making a choice, we always break these down into smaller components and we try to select one of these options. Then we want to address all the questions and concerns. On a practical level, this can be the most frustrating part of supported decision making. Because oftentimes if you have someone with, I think I had an Alzheimer's client once. Same question. Every 5 minutes, same question. Same question. So she'd ask it again, then you'd answer it. 45 minutes later, you've gotten through everything else, but you're still going back to this question every 5 minutes. So that can be frustrating. One way to Then you want to ask the person to make a choice or express an opinion. Now, when you do this, how we say things have a lot of unintended consequences. So when we want to offer choices, or when we want someone to express an opinion, what we can't do is make the assumption that because to us, this is an obvious choice, and this person should do this, that we're going to say something like, oh, you're going to, okay, well, I'm sure that you want this. So yeah, you want to go to the store at noon, right? Well, no, you don't ask it like that. Like, when would you like to go to the store? You're not supposed to put any of your own bias, any of your own opinion into how you express, how you ask the person to express their opinion. Then another thing you can consider is a supported decision-making agreement. So a supported decision-making agreement is just simply a way to put the supported decision-making relationship in writing. And what this does is it lays out who the supporters are, what the decision maker wants help with. So this can take a whole lot of different forms. There's some forms from the ACLU where it's essentially just a checkbox, where you're going to say, I want supporter A to help me with my healthcare decisions and my medical decisions. I want supporter B to help me with my medical decisions and my daily activity decisions. So this is just a way to establish some guidelines, and also to allow the decision maker to make the determination of whose opinion they really want. Now again, we should think about this in the context of the type of relationships that you're going to have. Your mom's going to be there probably for the decision maker. How many people have kind of complex relationship with their parents and being told what to do? Like we all do. That's sort of an inherent part of being raised by someone, is that we get into these long-term relationships and then we can't really change that relationship. And we don't really want their opinions on everything, you know. Over the course of my life, my mother has made clear that I should have a PhD. I don't want one. That seems like a lot of time for something I don't want to do. You know, so I would not involve her in my education decision making because she's made her point and we just disagree. So, you know, that's kind of why the supported decision making exists. One thing that you should also do with these supported decision making agreements, again, in District of Columbia, they have a statutory form for it. In Texas, they have a sample form in statute. In Colorado, supported decision making isn't in statute. But one thing that it's always good to do with these documents, if we want them to be kind of official, should be signed by each supporter, signed by the decision maker, and notarized. And sometimes those sort of protections, qualifications, I suppose, will make it a little bit easier for third parties to be able to rely on these agreements to make decisions. Mm-hmm. Now, one thing that we should consider is just how often supported decision making is already being used in our daily lives. So there are a lot of supported decision making opportunities out there. Locally, if anyone is familiar with the Colorado Choice Transitions Program, the program that transitions people from nursing homes to the community or assisted living, if that process is done properly, and like everything in the world, not everything's always done properly, but if it's done properly, that should be a supported decision making arrangement. And if any of you work in transitions through the Colorado Choice Transitions Program, please emphasize that point. Because you're not supposed to be assigning a person to a housing, you're supposed to be helping them get there. Some other examples: special education, the individualized educational plans. Those are supposed to be based on the student leading the process. That's a supported decision-making process, as well as transition planning. With the new Medicare and Medicaid regulations and rules that are coming out, these are supposed to be person-centered. So that means that we need to look at what's important to the person as well as what the person needs. And then we're going to help the person reach their goals. In the video we saw, that was a type of person-centered planning for Medicare and Medicaid care planning. And finally, you can put these agreements into power of attorney documents. So you can incorporate those language into, say, a medical power of attorney and say that supported decision making will be used to help with this sort of decision. But one thing that I really think people should be aware of is that you need to be very careful in doing this. Banks, hospitals, used to seeing a particular type of power of attorney document. And you don't want to add any language into it that would potentially invalidate the agreement or make it more difficult for a third party to rely on it. One thing that if you do find, and you would absolutely need an attorney to draft this into a power of attorney for anyone, but if supported decision-making language is incorporated, then it's also good to incorporate a cooling off period into the document. So how Colorado statute currently works is that power of attorneys So a cooling off period would be something where it would incorporate, say, 3 or 5 days, and say if the person says, I revoke my power of attorney because you're not supporting me, well then that wouldn't really take effect for 3 or 5 days, and if they still wanted to revoke after 3 or 5 days when everybody's a little bit calmer, then they'd still be able to revoke, but it wouldn't be immediately gone. So nationally, supported decision-making is growing. The Administration for Community Living, which is part of the U.S. Department of Health and Human Services, they founded a National Resource Center for supported decision-making a few years ago. It's also supported by the American Bar Association and the National Guardianship Association. The U.S. Department of Human Services, Health and Human Services, has also found that supported decision-making is consistent with the overarching goals of the Americans with Disabilities Act, the Older Americans Act, and home and community-based services. Now, what that means, because that sounds like a pretty boring statement, but what that means is that the department that's going to promulgate the rules for how we get people services has said supported decision-making should be used. So pay attention to that for any of you who are service providers. This is coming as new nursing home regulations come out, as new Medicaid planning regulations come out. Everything is shifting to person-centeredness. And supported decision-making is person-centeredness operating in the ideal form. It's person-centeredness where the person is truly in control. So this is going to be coming, particularly in how services are applied for and received. Next big thing is the Uniform Guardianship, Conservatorship, and Other Protective Proceedings Act. So at the national level, there's something called the Uniform Laws Commission. And in the United States, we have federalism. So all states have different laws. But we still like those laws to roughly match up. For any of you who do know lawyers, you'll find many are reluctant to practice or try to pass the bar in Louisiana, because that's just so far from everything else. So while we try to keep, while we all have our different laws, we do try to keep them sort of together, sort of similar in a lot of ways. And what the Uniform Commission does is, after years of research and planning, they will submit a document that says, well, we think that this is what a model law would look like with regard to your statute. And eventually these are going to be adopted by most states. In Colorado, we haven't adopted this particular provision of the uniform laws yet, but it's coming. There's probably going to be a bill on this next year. And what this act says is that prior to the use of a surrogate decision maker, prior to the use of a guardianship, we need to make sure that less restrictive measures wouldn't also fulfill that purpose. And when we look at less restrictive measures, we need to look specifically at supported decision making. So listing supported decision making in the uniform laws, the laws that a group of really smart lawyers have decided should apply to every state, they think supported decision making should be in the statute. All right. So I think this is a pretty good time for a little bit of a break. And Anne handed out a worksheet where it says the story of John, my first supported decision-making case. And also on the back, it has a chart where you can talk about his values and preferences, areas for concern, and additional supports in financial, medical, housing, and daily activities. Because those are generally the 4 areas that you're going to look at in a supported decision-making agreement. So if everyone could just maybe talk to the person next to you, just take 5 minutes to try to think about some other ways that John could use supported decision making. And also at the bottom, there are barriers to communication and how supporters can assist in overcoming these barriers. And just try to think about this for a little bit. And this isn't a great space for this, but supported decision making you learn by doing. So we're gonna try our best here. Yeah.
So just be mindful of that as you're moving it around, otherwise it'll make a feedback noise. Thank you for your help on that. Yeah.
I just think, I don't know whether she could take up right now. I just think it would be super helpful if she were more clear about what's guardianship, what's conservatorship, because at least in my understanding, those are very different things. And then, okay, what's medical power of attorney, what's power of attorney, and I don't know, and we're competency things. I don't know, I just feel like this is hard because it feels a bit disjointed, or I feel like there's not quite the flow of, I mean, for me, conservatorship and guardianship is like when people, that's in place only if they're become considered incompetent and haven't already had the power of attorney and medical power in place. Anyway,
Okay, I'll ask her to do that after the break.
because here it becomes you need to perform these different things. It's not something that can happen in the adult self.
Well, I mean, it is, because it is kind of an approach and a philosophy.
Yeah.
Okay, so I'll get her started on that, but if you have clarifying questions after the start session, you can chime in. Just use the microphone.
That means like it's not just
Because we're live streaming to public people, I have a question about, can we go back and just kind of explain the difference between conservatorship and guardianship? And then I think there's going to be some questions too about, well, then what's in an appeal? I think we have time. So, well, the gal that I gave the microphone to has the questions. So I said I would get her started on it and she can answer clarifying questions. If you're okay with that. I mean, do your
Yeah.
reconvening and whatever you're going to do there, but then just
Do them.
yeah, talk a little bit about that. Because I guess she's saying in her mind, you know, like empty POA and POA, like she gets that kind of piece, but conservatorship and guardianship in her mind is if it's more in depth and more down the road, and it's after like empty POA and POA, not necessarily like just more layers is what she answered. Okay. So you had a backstory. Thanks.
Okay, so we're about ready?
Okay.
All right. So did anyone come up with any other concerns that we didn't talk about in the practical example? You want to share? Okay. All right, what about barriers to communication? Stroke? Yeah. Yeah, the stroke. So what are some potential ways you could assist in overcoming that?
Oh, fun, a microphone. So I guess it depends on what types of therapies the client is receiving, whether or not there's going to be improvement in his communication or whether or not there was damage done that prevents him from communicating well, and then seeing whether or not that hinders him from making some of that or being able to communicate his feelings, his values in that capacity.
Yeah, that's exactly right. And then with those kind of issues, then we think about what sort of services, if necessary, could we try to find for him to be able to assist with that? Like, does he need speech therapy, like as you alluded to, that kind of issue. Some other things that you want to consider as barriers are potentially He has trouble with memory. He has trouble, which we talked about, so I know you all know that. But just some ways that you can overcome the memory issue, such as, written down before. People with memory issues, as a general rule, are a little bit sharper in the mornings. So you want to make sure that you get to them at a time of day when they can really think. Because, as anyone who works with me know, if you talk to me after 4, it's pointless. It's just not going to work. All right, so I understand we had a question coming in about guardianship and conservatorship and power of attorneys.
Yeah, well, yes. So, but again, I don't want to necessarily totally redirect this presentation, but in some ways for me, it'd be helpful just to have a little bit of an overview here in the state of Colorado, kind of power of attorney, medical power of attorney, conservatorship, and guardianship, because at least in my understanding, ideally, people have the power of attorney, medical power of attorney set up first, and then guardianship and conservatorship don't become necessary, and that guardianship and conservatorship typically are set up when people haven't made previous arrangements and are no longer considered competent. And so just a little bit more how those things play, and that I've always understood guardianship and conservatorship to have pretty distinct roles. So a guardianship typically isn't the person making kind of financial decisions. That would be more in the conservator. Right. But can those things be combined? So just a brief overview would be helpful. Thank you.
Yeah, we'll just give the sort of 2-minute rundown.
Yeah.
So for power of attorney documents in Colorado, we have a medical durable power of attorney and a financial power of attorney. What the medical power of attorney does, and what all power of attorney documents are what are called advance directives. That means that these are things that are written in advance of incapacity. So what a power of attorney for medical decisions will do is either it can be more of a broad, this person is empowered to make all of the medical decisions for me, like my husband's empowered to make medical decisions for me. Or it can be something more narrowly tailored, where you can list out specific decisions in healthcare that you'd want someone to make. Then financial power of attorney. Financial power of attorney is used to make financial decisions. Oftentimes people can have this in place for long term for things such as operating businesses. And that's someone who would be appointed to make decisions for you either at the time that you choose. So either at the onset of incapacity or when the document's signed. And that's the same situation that can go with the medical power of attorney. So these are advanced planning, estate planning documents that we should all have, because if anything ever happens to us, this will make it a lot easier for our families. And those are things that are done in advance. Guardianship and conservatorship are things that are done through a court process. Power of attorney documents don't need to go through the court. So when you have, and the way that you get a guardian and a conservator are very similar, so I'm just going to talk about them as one. To get one of these, what you're going to do is you're going to file a petition with the court and say that a person is incapacitated and they can't make these decisions for themselves. And then the court will look at it and say, okay, this is true. For a guardianship, it would be that the person is incapable of making any decisions. The court is then going to make a finding of incapacity, that the person cannot make decisions, and appoint a guardian. That guardian, once appointed, will serve until they're removed. So that goes on until the court says it doesn't. And this person, what guardians can do, we talked about quite a bit, but guardians are generally for decisions related to the person, not the property. So this would be your healthcare decisions, your housing decisions. But in some cases, guardians can have limited financial responsibilities. Conservators are, the court will go through the same petition process, and then the court will find that the person, by clear and convincing evidence, cannot properly manage their estate. Not necessarily finding of incapacity, but that they can't properly manage their estate, so we're going to put someone else in charge of your money. Conservator is entirely financial. And they can do many things. One thing they can't do is revoke a financial power of attorney, which is important. And a conservator, like a guardian, is going to go on until it's terminated. So both guardian and conservator are things that would be done for someone who no longer has capacity. And capacity means that you really just don't have informed consent anymore. You don't have the ability to understand, to really understand and fully evaluate your decisions in how you're doing things. So it's sort of like a contract. Like, do you really understand the terms of these contracts? Well, no. Well, then you can't, you don't have capacity for it. So does that answer your questions
Yes, thank you.
generally? All right.
If you feel like someone doesn't have the capacity, how is that proven or not, so that the document hasn't been made, the documents that weren't made in time, now a person shows signs of dementia, and is the only right way to proceed is to proceed through the court, because the other documents weren't done before that?
So if I'm understanding this correctly, your question is, if someone does not have capacity and doesn't have power of attorney, do you have to go through the court?
No, is that the direction that we should all be looking, to advise someone to go through the court, now that the person that they're helping or they love has already shown signs or a diagnosis of dementia? Should you not then pursue a medical power of attorney and a financial power of attorney? You should advise them strictly to deal through the court.
Right. Yeah. So if a person does not have capacity, they cannot, then they do not have the capacity to contract, so they cannot execute a power of attorney document.
Yeah, but
So
say that they have only the beginning of dementia.
Then,
That's been documented. Then would their power of attorney that they would want to have written up actually be challenged later on?
it depends on the capacity to contract. So what that means is that in order to contract, under contract law, what you need to do is you need to understand the terms of the contract, and none of those terms are affected by an insane delusion. So which is something where if you're looking at something very specific in the contract and the person is just perseverating on it and it's not correct. So for a power of attorney document, a person has to be able to understand, first, we're in real murky territory. You want to be very, very careful in these situations. But for a power of attorney document, someone needs to be able to understand what they're giving away. They need to be able to understand what that document means, what it says, and who they're empowering to do what. If they can't do that, if you don't think they can do that, then I believe it's unethical to even pursue the document. Because one big difference between power of attorney documents and guardianships and conservatorships is that guardianships and conservatorships, they happen through a court process. They happen through a petition and notice and hearings, right? That's due process. Power of attorney documents don't. So if someone's going to sign this, they really need to understand what's in the document. Does that answer your question?
So that means that somebody would have to prove, in order to challenge the one that wasn't written up, they'd have to prove that the person had no ability to understand what they were giving up at the time they signed it. That would be the person challenging it.
Yeah, if you went into litigation about that, yeah. Yeah.
I had a question with the guardianship. When you mentioned that someone can like their guardianship until they're removed, how does one get removed, and what if the person that was given guardianship is not, like you said, they don't track how they're being responsible with that person, and if they're not, and that person knows it, how do they get removed?
Sure. So to remove a guardian, first a guardianship will terminate if the guardian dies or if the ward dies. So that's one way to terminate it. That's obviously not ideal. But in order to terminate a guardianship, what you need to do is petition the court. Any interested party can petition the court to say this guardian's acting inappropriately and should be removed. Generally, if the ward can write a letter, it can even be a handwritten letter, and just submit it to the probate court and say, I have these problems and I need a hearing, then in a lot of cases the court will actually grant that. And they'll come in and talk and see if a guardian can be removed. A guardian can also ask to be removed if they're under a lot of pressure to do so, or if they don't want to do it anymore. Again, it's the court's discretion whether or not to allow that to happen. And one issue that we do run into is that there aren't enough guardians in a lot of cases. So if someone doesn't have friends or family members who are willing to come in as an alternate, then we can get into a little bit of trouble of, okay, well, this guardian may not be perfect, but at least it's a guardian, and they can sign this paperwork, you know, so the person can get their Medicaid benefits. Situations like that. Okay. All right. So let's just go into some challenges and limitation with support.
If a person is an alone senior and they don't have any heirs and they don't have a husband, now they're out of capacity, but they run out of assets. Who's acting on their behalf? Is there such a thing as attorneys that do this on a volunteer basis? Who does act on their behalf when they have no one left?
So in Colorado, we have a patchwork system of volunteer guardian programs, and some, about a half to a third of county departments of human services will take guardianships to make limited decisions for them. For those individuals who are, you know, isolated, don't have friends or family member who can serve as guardian, don't have any resources, can't hire a private guardian, oftentimes we just can't find anyone. You know, Silver Keys is a really good organization in Colorado Springs that does provide volunteer guardianship services. Silver Keys, but last I heard their wait list was a year long. So, you know, one thing, I am on the Office of Public Guardianship Commission, and we've been trying to establish a statewide office for that. Initially, this was something passed that would do a pilot program to allow us to collect some data on the needs of guardianship for exactly that situation. It was to be funded by gifts, grants, and donations. We could not raise the money to fund a public office. So we've gone back to the legislature this year to ask for general fund appropriations. We have been told that we probably wouldn't get our whole office funded, but we're trying to get at least a Denver Office of Public Guardian, an office for the Denver area, funded to do exactly that services. But, you know, call your congressman. It's been held up right now, so we're going to have to see how it goes. It's 1045, HB 1045. All right. So we good on this subject? Got more? Is there a band? All right. All right, so challenges and limitations. So, I mean, you can probably imagine there are a lot of challenges and limitations with supported decision making. One thing that we should consider are challenges with supported decision making and older adults. One issue that you know is happening internationally is that the older adult community isn't as invested in supported decision making as some of the disability community is. And there are a number of reasons for that. First, you have to think about the situations when guardianship would be pursued by someone. So if you're a parent with a child with an intellectual and developmental disability, when they turn 18, generally you're advised to go get a guardianship. Well, I mean, just think about that. For a parent whose child finally reaches adulthood, they're finally able to go out and make their own decisions. Well, getting a guardianship is really painful. Supported decision making is a welcome alternative for a lot of these families to be able to engage in it. And just to give you an example about the severity of this problem, can anyone know what the largest referrer of guardianships is in the United States?
What the largest what is? Who's
the largest referrer of guardianships? Schools. So that's not something many parents want to do. But then if you think about a situation where it would be an older adult who, where we're thinking about getting into a supported decision-making process. Well, generally a guardianship petition is filed in response to some sort of an event. So this could be something like a stroke, the onset of dementia. And they can also be filed to deal with sort of time-sensitive matters, such as filing applications for long-term care benefits, and things like that. So there is some urgency to this. And oftentimes that urgency, the efficiency of a surrogate decision maker, really takes precedent over trying to sit down with someone who is going to have a lot of difficulty making decisions to get a decision made. And one thing that we should be very clear about is that it's always easier to tell someone what to do than it is to try to encourage them to make a decision. Power of attorneys, guardians, they will always be more efficient than supported decision making. Next issue is isolation. People with disabilities are isolated, but statistically, older adults are more isolated. So, and if you think about this, for older adults, I mean, many of their friends and family members have passed away. They also aren't getting out as much. So this isolation can put it in a situation where there are fewer supporters. Next, and all credit to disability advocacy organizations, but over the past probably 20, 30 years, they've made a concerted effort to tie legal capacity to civil rights and autonomy and freedom. So they've been working on this issue for a long, long time. For older adults, those sort of advocacy efforts go in different directions. We work on financial exploitation. We work on finding cures for causes of dementia. So it's just sort of a different priorities for this different population. Then also, and I talked about this a little bit before, goal of supported decision making is building decision making skills so that people can be more independent. For older people, many people don't think that they need to build these same skills. As I said before, I think as the brain changes, yes, you do. And one thing, the reason Australia is up there is because they do quite a bit of supported decision making with older adults. And they found that they can make it effective. Same time, a study by I think it was the Alberta government in Canada, found that supported decision making is not used as often for older adults as it is for people with disabilities, even when they have equal rights. So maybe some of it's outreach, but it can be used. So one other thing that we should talk about is the prevention of unnecessary guardianship petitions. Just simply having the supported decision-making option, even if eventually you want to go to a guardianship, even if you need to go to a guardianship, having that petition there, or having the supported decision-making as an option, can prevent people from filing for a guardianship to begin with. So that can reduce guardianship. Right. Next limitation is training friends, family members, and other advisors. So there are a couple problems with this. First, who's going to provide the training? We'd need to get people trained on supported decision making, and then we would need to have resources to put into training. A second issue is that this is not intuitive for all people. Helping someone make a decision is without having any of your own opinion or your own drive to protect or help isn't always easy. So people need to be trained on exactly what supported decision making is, exactly how this can be used to help someone make a decision without putting your own biases into it. And this is hard. We all do this every day. And we also need to go back to what we said before about the long-term relationships. Changing dynamics in long-term relationships is extremely difficult. And for people in supported decision making, they're going to, in some cases, just flip it on their head. And that's hard to do. Next issue is resources. You can imagine financial resources to do this, sure. What about the human resources? All right, this takes a lot of time. It takes a lot of work. You need to make sure that supporters are willing to invest the time in being able to do it. You also want to think about professionals. If professionals are going to be used, would they have time off work to do this? Would they have to work on weekends? And then you want to think realistically, do these supporters do you have the human resources? Do these supporters have the time to actually go through this process and make sure it's effective? And then we also want to think about what if the situation where someone doesn't have a lot of supporters to draw upon? Well, there are a couple of strategies that you can do for this. You know, you can help reunite with family members that were once close and aren't anymore, or develop closer relationships. You can also provide information on support networks, social support networks, like say, hey, you know, this, you know, senior center has this activity. Why don't you go and see if you can make friends? And that kind of thing. And then there are also some volunteer or paid supporter programs that could be drawn upon. So, you know, it's possible that we can generate supporters, but it's also possible that we can't. People may not have supporters, people may not have the supporters with time. And then something that advocates, people in the helping professions really need to be aware of is benevolent thinking. Thinking that you know what's best and that you're going to protect them and that you're valuing their independence, but I know you don't want to do that, and that's okay, and you're going to be safe here. That's really dangerous. For people who really care about independence, for people who really care about advocacy, this is the biggest barrier for them to participate in supported decision making. We have trouble getting over our own biases. So just for example, so we're going to talk about your housing. Well, you don't want to be in a nursing home. No one wants to be in a nursing home. Well, I know your brother said that, but I mean, who wants to be in a nursing home? Well, some people actually do. Not a lot, but I have had clients that have wanted to live in nursing homes. So we can't impose those values on it, even if we think it's best for them. No, it's what they want. All right. So other challenges are abuse and exploitation. Undue influence is a big one here. So here's what we know. We know that power of attorneys and guardianships have been abused. We know that they can be abused. So we have no reason to think that supported decision making won't be abused. No, there are some states that have drafted into their statute sort of a mandatory reporting requirement, where, you know, if you see this, then you have to report it, or if you're concerned about this, then you have to report it. But at the same time, this process would not have any, supported decision making would not have any oversight or due process. So again, we want to avoid the situation where it's a bunch of people sitting around the table making decisions for another person without any oversight. All right, that's very dangerous. And that's why you need to make sure that there are well-intentioned and strong and highly supported advisors in this process. Another problem that we run into is conflict of interest issues. So just for example, I had this client a few years ago with a guardian. And that guardian was a private guardian that he was paying, and the guardian also had a number of other service providers that worked with her. So she had a psychologist on staff, she had a home health care agency, she had a house cleaner, a cook on staff. And in the end of it, when we were talking to him, he was like, oh no, but my guardian thinks it would be a really good idea for me to have counseling 3 times a week. He didn't have any diagnosed mental health problems. So that's the kind of thing that people can get talked into, is that they drain their resources to fund their own businesses if you put professionals on these teams. And don't get me wrong, sometimes professionals are necessary, and just because you have a financial interest in something doesn't mean that you can't be a decent human being. But we all need to be aware of this. And if you are in a supported decision making, you should screen for conflicts. Screening for conflicts would be part of that practical guide that we went through before. What are the challenges the supporters could have? So this is always a concern when the progressive haven of Texas is leading the way on a civil rights issue. So Texas has said that under their statute that before placing a person under guardianship, the court must find by clear and convincing evidence that no less restrictive alternative, including supported decision making, is allowed. Texas also has a restitution of rights statute for people under guardianship. So, Texas is a little bit ahead of us on this. And this is concerning because there are only a few states that have really integrated this fully into their legal system. Some other ones, Delaware has a statute that recognizes supported decision-making agreements as legally enforceable. In July of this year, Maine's going to have a new probate code put into place where it's going to specifically require supported decision-making to be attempted before guardianship's put in place. And then the District of Columbia and Indiana also have some laws. But really, that's just a handful of states. Maybe when the uniform laws come out, this will grow more. But still, it's a small issue. And in Colorado and nationally, what we're doing right now is just largely nonprofit or advocacy organizations who will just try to facilitate these arrangements. There's also some promising case law out there. So in Vermont, there was a case where a man was appointed a private guardian by the court. And that guardian talked to him, and here is evidence that I'm not totally against guardians. That guardian did what she was supposed to do under the statute. She went, she talked to him, she tried to understand his values and needs, she tried to understand what he wanted and how valuable this was going to be for him. And then after talking to him for a while, she went back to the court and was like, if you talk to him, he can make his own decisions. This is really unnecessary. You paying me to do this is unnecessary. And she went to the court and told them this, and then the court said, okay, we'll terminate the guardianship and put a supported decision-making agreement in its place. So that guardianship was terminated in favor of the supported decision-making process because it was correct for this person. Now, the final big challenge is informed consent. And you alluded to this a little bit more. What is informed consent? That's hard. I mean, by definition, informed consent is a decision made with a full understanding of the risks and alternatives. How do you know if you've gotten someone to the state of informed consent? There's no bright line rule. You do your best. In Colorado, we all have capacity until we are adjudicated incapacitated. And, to a certain extent, we have to give people the benefit of the doubt. We've also found that by using some of the enhanced communication techniques that supported decision-making does use, that you can raise someone to the state of informed consent. So, for example, for dementia patients, they found that if you communicate in a way that minimizes memory demands and verbal retrieval, then they can come to the state of informed consent. So my answer to this is you need to be careful. People need to understand what they're doing, or again, if they don't understand the decisions they're making, this isn't empowerment. So do your best. Try to find a way to make them understand. Try to run your own sort of tests, I guess, as to whether or not they understand. Ask them questions. But informed consent is just a tough one to do. And these are the, is there a question?
It's not really a question, but in Colorado, when we make a power of attorney, we require a notarized document and a witness to the person's decision and their signature. But we allow people to carry around a copy of their document and use that copy to stand in place of an original that has an original signature and a stamp on it. And a friend of mine had their documents made and carried a copy in their glove box, got into a car accident in New York State. Their state requires, in order for a document to be considered at all, it had to have been the original, and it had to have 2 witnesses, not just one. Mm-hmm. And it's different in every state. And in advising someone who's senior, who's like I'm with the Alzheimer's Association, and in talking to people, I'm saying, yes, these documents need to be prepared, but we need to prepare them so that they're at the highest level of their ability to be used, especially with so many of our clients leaving the state for a warm climate in the wintertime, and the attorneys that are working for them here are not preparing them to be a traveling client and have to have a document that's effective elsewhere.
Yeah.
And I'm thinking that it's important to understand that when you're talking to a client, where is their living occurring, or are they going to potentially travel or even take cruises, and know how to prepare them to carry and use documents that are actually going to be effective and protect them when they're away from their state here.
Sure, and that situation can happen. Under our statute, we do have, agreements with other states where we try to recognize their documents, and most states try to recognize ours. This type of issue is why the Uniform Laws Commission tries to get more uniform laws in the state. But it can be tricky, and one thing, this is CRAP, going back to abuse. If you do have an out-of-state document that you're not sure about, and somebody's coming in and saying, this isn't my out-of-state document and I'm going to make the decisions for this person, well, if it's not a real document, then that's abusive. One technique that I have seen some attorneys use for this is to draft them the power of attorney here, and then if they're going to go to Arizona or Florida for half the year, then they should also contact an attorney in that state and have their own power of attorney document drafted there. So for informed consent, again, it's difficult. And this is the Colorado Rules of Professional Conduct. So these are the ethics rules that attorneys are supposed to follow. And again, this is attorney specific, but one thing about law is that we're just a bunch of people who sat around and tried to think of things in a common sense way and write them down so that we'd have rules for how to operate. This is for lawyers, but it really applies to anyone. If you are working with someone with diminished capacity, then as far as reasonably possible, you need to try to maintain a normal relationship with them. And that includes communicating with them if necessary, only taking protective actions if necessary. And the fact that a client suffers from a disability, and under the rules of ethical conduct, the definitions are strange. This is about diminished capacity, so it would be older adult, not just persons with disability, for clarity. It doesn't diminish our obligation to treat the client with attention and respect. So we need to treat them like a normal client. Talk to them, communicate with them, constantly be keeping them in touch with them in order to find the best ways to serve them. All right, so that's about all I have. Are there any questions? All right.
Thank you so much.